Everyone is suing Logan Paul, which is weird because he seemed like he took legal obligations so seriously.
I had to rely on my team. I crumbled internally.
But things aren't looking great for Logan Paul or his Prime Energy drink company. Dramatically declining sales are only the tip of the iceberg and have caused him to be sued by not just the US Olympic Committee, but also the manufacturer of the drink. As many YouTubers have found out, your fans can propel you to huge success on the streaming service, but selling products away from YouTube is about much more than a hungry fan base. And if you don't cross your legal T's and dot your legal I's, you could be in a lot of hot water. And that's where Logan Paul finds himself today, thanks to 2 lawsuits that may sink his popular beverage brand. The US Olympic Committee is suing Paul for trademark infringement, and Prime's manufacturer said that Paul breached their contract when sales of the drinks started to tank. So today we'll be breaking down those 2 lawsuits. Now, Logan Paul has a knack for making quick money, scamming people, and getting punched in the face. And our last video about Paul covered his bonus defamation lawsuit against CoffeeZilla. Now, fighting this lawsuit is costly, and you can check out CoffeeZilla's video on how you can help. But the current dust-up is about Paul's beverage line, Prime, which launched with influencer KSI back in 2022.
We made a better-for-you drink that tastes better.
Yeah. Prime currently has 2 offerings, Prime Hydration, which doesn't have caffeine, and Prime Energy, which does. A 12-ounce bottle of Prime Energy has about 200 milligrams of caffeine, which is the equivalent of about 6 cans of Coke. Now, demand for both products was initially through the roof. People lined up at dawn to get the new flavors, bottles were sold out on eBay for thousands of dollars, and people literally fought each other to get their hands on the orange mango flavor. And of course, both Logan Paul and KSI have been involved in various controversies over the years, from problematic content on YouTube to highly publicized personal feuds. These controversies have spilled over into their business ventures, including lawsuits and inquiries by several US states and many more European countries. Basically, wherever Prime's beverages have appeared, they've also been the target of the law. For example, Canadian and New Zealand regulators banned Prime Energy because it exceeds their regulatory limits for caffeine. But in the US, there is no legal limit for the amount of caffeine that companies can put into their energy drinks. And thank goodness for that, America. But we discussed high caffeine levels in the video that we did on Panera Bread's Charged Lemonade. And when the same concerns were raised about Prime, Senator Chuck Schumer asked the FDA to investigate Prime Energy. And in April, consumers filed a class action lawsuit accusing Prime of mislabeling the amount of caffeine in each drink. Though Prime says its energy drink has a warning label that it is not recommended for children under 18 and that it contains comparable level of caffeine to other competitors. Now, obviously, if you're getting sued by the notoriously litigious US Olympic Committee, you want a good lawyer. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've gotten in a car or trucking crash, suffered a data breach, especially if you got a letter saying that your social security number might have been hacked, or are dealing with a sexual harassment suit, we can represent you or help find you the right attorney. Because it's so important to talk to a lawyer right away so you can maximize your recovery and find out what your options are. So just click on the link in the description or call the phone number that's on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. So you can click below. But Paul and KSI are now facing 2 additional lawsuits that show how sloppy Prime is at business. In a complaint filed on July 29th in Federal District Court of Colorado, the U.S. Olympic and Paralympic Committee, or USOPC, sued Prime for the unlawful use of Olympic trademarks. The complaint alleges that Prime, quote, in a deliberate and willful attempt to trade on the USOPC intellectual property, used Olympic-related terminology and trademarks in marketing its products on internet advertising and in promotions for a Prime hydration flavor featuring Kevin Durant. The infringed trademarks include Olympic, Olympian, Team USA, and Going for Gold. Now, I first heard about this lawsuit from Legal Bites, who made a video explaining why Prime was in legal trouble. This lawsuit came out when there was a lot going on in the world, and I was focused on other things. But you should really check out the video. She does a good job of explaining U.S. trademark law, including why an official Team USA merchandise licensee has significant value to brands. As you probably know, a trademark can be any word, phrase, symbol, design, or combination of these things that identifies goods or services. The purpose of U.S. trademark law is to allow consumers to easily identify producers of goods and services and avoid confusion. And because of that, a trademark can last indefinitely so long as the user is using it in commerce. Unlike copyright or patent law, which eventually expires. Now, with respect to the Olympic Games, for decades, brands have known that when consumers see a product with the words Team USA or the image of a popular athlete, they are more willing to buy it. And so if a company wants in on US Olympic glory, it has to become a licensee of the USOPC. And the USOPC gets to decide who can use those trademarks and where they appear. So for example, if you see a Wheaties box featuring Katie Ledecky or Simone Biles with the words Go for the Gold, that's because Wheaties paid for a license. And lots of companies work with the USOPC, such as Coca-Cola, Polo, Eli Lilly, Cisco, Warner Brothers, Delta, Fanatics, and Visa. And of course, Prime is not on that list because it never negotiated a license. However, the label on the bottle of Prime's Kevin Durant-themed hydration drink features Durant's name emblazoned above a curiously patriotic-looking Prime logo. The bottle also talks up Durant as the 3x Olympic gold medalist and counting. The text says when KD steps on the court, he's going for gold. And the complete features lots of ads that Prime Hydration placed on social media and on its official website, as well as advertisements on various social media platforms and physical printouts for stores selling the drink. For example, quote, Prime Hydration provided ad copy to stores selling the infringing product that prominently used the Olympic marks, using the word Olympic 6 times in ad copy, including 2 uses of Kevin Durant Olympic Prime drink. Celebrate greatness with the Kevin Durant Olympic Prime drink. Olympic achievements, Kevin Durant Olympic legacy, and other uses. Now, I found this to be fascinating because not only does the USOPC have the rights to the trademark by right of trademark law, but they actually got it written into law. 36 U.S. Code 220506 grants the U.S. Olympic Committee exclusive rights to the name, seals, emblems, badges, all of that associated with the Olympics, including the name, the United States Olympic and Paralympic Committee, and the symbol of the International Olympic Committee, as well as related words and phrases, including Olympics, Olympiad, and Paralympic. And the law says that the Olympic Committee can bring a civil lawsuit under the Trademark Act of 1946 against a person who, without the committee's consent, uses the Olympics-related symbols, emblems, and words mentioned earlier for the purpose of trade to induce the sale of any goods or services, or to promote any theatrical exhibition, athletic performance, or competition. Now, the law does include some exceptions from civil suit, mostly to do with place names and regions with variants of Olympic in the name, such as Olympia, Washington, but unfortunately for Prime, they aren't one of the exceptions. And the second claim for relief is a regular trademark infringement claim under the Lanham Act. The complaint alleges that Prime's use of the Olympic trademarks is likely to cause confusion, mistake, or deception about the source of its products, thus infringing on the USOPC's trademark rights. And in the U.S. courts evaluate a claim for trademark infringement primarily by analyzing whether there is a likelihood of confusion between the plaintiffs' and defendants' marks. And most courts use some combination of the factors set forth in the case of Polaroid versus Polarat Electrics. These include the strength of the senior user's mark, the similarity of the two marks, the similarity of the products or services, the junior user's intent in adopting the mark, and the sophistication of the buyers. And courts will also consider evidence of actual confusion by consumers. And another issue is whether there's similarity of the goods. And here the USOPC is right that its mark is frequently used on similar goods. Powerade is the official sports drink of Team USA, and Prime is its direct competitor. The USOPC sent a cease and desist letter on July 10th, but it alleges that Prime continued to ship products and use the marks on social media. The company continued to feature both the bottle and copy on LinkedIn, making it look like it deliberately wanted to use the goodwill associated with Team USA to promote its own products and brand. There's a third claim for unfair competition and false designation of origin in violation of 15 U.S.C. 1125. And there's a fourth claim for trademark dilution. Now that's interesting because dilution occurs when a third party uses a mark or trade name in commerce that is sufficiently similar to a famous mark such that it harms consumer perception of the famous mark. The complaint says that, quote, the USOPC has used the famous Olympic trademark in interstate commerce since at least as early as 1896, which is prior to the use by defendant. It notes that, quote, the Olympic marks have been used in commerce by the USOPC for decades, and billions of viewers around the globe are expected to tune in to the games this summer. Prime Hydration's use will dilute the distinctive quality of the famous Olympic marks under Section 43 of the Lanham Act and injure the USOPC. And the courts have given the USOPC even stronger protection for its trademarks than it would have under a normal trademark claim under the Lanham Act. In San Francisco Arts and Athletic Inc. versus United States Olympic Committee, the Supreme Court barred the San Francisco Arts and Athletics Company from using the words Olympic in its gay Olympic Games. The court held that the committee had the exclusive rights to the word Olympic under the Amateur Sports Act of 1978, and could prohibit its use without needing to prove trademark infringement or consumer confusion, which you would normally need to do under a trademark action. The court ruled that this exclusive right was constitutional and did not violate the First Amendment because the committee's use of the word served a legitimate purpose and its protection did not unfairly restrict free speech. And courts interpret 36 U.S.C. 380 broadly. It gives the committee the sole power to use the International Olympic Committee. It gives the committee the sole power to use the International Olympic logo consisting of 5 interlocking rings. For example, in USOC versus Interlicense Corp., the committee sued a marketing firm for publishing pictograms using the Olympic rings mark. Quote, the pictograms at issue are graphic designs of athletes participating in various summer and winter Olympic sports against a backdrop that explicitly incorporates the Olympic symbol consisting of 5 interlocking rings. The International Olympic Committee had given the firm permission to use the rings, but the Second Circuit Court of Appeals said that that was not enough. Interlicense needed the USOPC's permission to use the rings in the United States. And some argue that the USOPC takes this protection to the extreme. For example, in 2005, the committee threatened to sue the Improv Olympic Theater if it did not change its name. The Improv Olympic Theater helped launch the careers of Stephen Colbert, Seth Meyers, and Bob Odenkirk, among others. And the group had been using the name for 20 years, but it changed its name to IO to avoid the lawsuit. But Logan Paul might have some exceptions. There is an exception to U.S. trademark law known as nominative fair use that may help Prime. Nominative fair use permits the use of another's mark to refer to the trademark owner's goods and services associated with that mark. This is permissible as long as the use is necessary to identify the product or service, the use is limited to what is needed to make the identification clear, and the use suggests that the trademark owner endorses or is affiliated with a user. The nominative fair use doctrine was created in a case that involved the New Kids on the Block versus two newspapers that ran polls gauging the band's popularity. The court ruled that the use of the band's name did not violate the trademark because it was necessary to identify the band and did not suggest sponsorship. So hypothetically, Coca-Cola could say it's better than Pepsi, even though Pepsi is trademarked, because there's really no other way to identify the product other than calling it Pepsi. For example, in Playboy Enterprises versus Wells, the Ninth Circuit ruled that Terry Wells' use of the term Playboy and Playmate on her website was nominative fair use because it accurately described her former status and did not imply Playboy's sponsorship or endorsement. The court held that Wells was allowed to mention the name Playboy and use the related terms like Playmate of the Year or PMOY, but she couldn't use Playboy's most distinctive mark, the Playboy Bunny. So you can see how that might apply here. First, we look at whether the trademark is necessary to identify the product or service. And in fact, this often comes up when you're talking about the Super Bowl. And for various reasons, people have come up with some very creative ways of describing the Super Bowl. But for example, the Pittsburgh Steelers have won 6 Super Bowls. If you wanted to describe this level of success, you couldn't really get your point across without saying the phrase Super Bowl, even though that's trademarked. It would be strange to say the Steelers won 6 really big games. The second factor is whether you're using as much of the trademark as necessary. So in that context, the phrase Super Bowl, which is a trademark, is probably okay, but your use of the Super Bowl logos, that's probably a step too far. So similarly, Prime is probably free to say that Durant won 3 gold medals, but the company probably can't use the Olympic rings. And the third factor is that you can't create the impression that you're affiliated or endorsed by the user. And that's where the USOPC has gotten very aggressive, and they will police any suggestion that a company or person is formally affiliated with the US Olympic team because it's trying to protect the value of the sponsorship that it sells. But here, the Wells decision might actually help Prime argue that it had a right, with Durant's permission, to describe him as an Olympic champion and a gold medal winner. If you take a look at the bottle, it doesn't seem to use the font favored by the USPC, and Durant isn't featured on the bottle wearing his Team USA uniform, and there's no other indications that the Olympic Committee is partnering with Prime. And so the USOPC is seeking all the profits associated with the sale of Prime, which the committee claims is in the millions of dollars. It also wants damages for harm imposed on its sponsorship agreements with its licensees. But Prime has yet to respond to the lawsuit, possibly because it's busy fighting another major lawsuit, which is about the lack of success of Prime. It's really getting whipsawed here. In November of 2023, Bloomberg concluded that Prime was on track to make over $1.2 billion in sales. Prime and its branding company Congo were bullish on the company's future. With supply outstripping demand, the company looked for a manufacturer that could handle the large orders. So they turned to Refresco, a beverage manufacturer that produces products for various brands and retailers. And in 2022 and early 2023, Refresco acted as the bottler for Prime, but only on a spot basis, meaning that they would only accept irregular orders on demand. However, this arrangement was costly because it required Refresco to purchase from third parties unfilled bottles that had been fabricated for Prime's unique design and trade dress, including the shape and size, because specialized molds and related equipment are needed to fabricate those bottles. And in early 2023, Prime wanted to lower its production costs by limiting the deals with third-party bottle suppliers. So Refresco allegedly informed Prime that a production line in its Truesdale, Missouri factory had become available. And to produce its products, Refresco would need to refit a dedicated line with new equipment, including some that would be custom-made to accommodate defendants' bottles. According to Refresco, in the normal course of business, customers pay for or finance the cost of ordering all that equipment, but Prime and Congo were not willing to reimburse Refresco for the dedicated line. Allegedly, since Refresco would be unable to use that line for any other customer, the company asked Prime to minimize its risk by agreeing to minimum orders for 3 years. Prime allegedly agreed to order a minimum of 18.5 million cases, or 222 million bottles, for a total of 55.5 million cases cumulatively over the 3 years. And apparently there was also a take it or pay it arrangement. Quote, if defendants did not purchase and take delivery of at least 90% of the agreed annual volume commitment for each of the 3 contract years, defendants would be obligated to pay Refresco a fixed shortfall amount for each 12-bottle case below the volume commitment that defendants did not purchase. The parties called this contract the Truesdale Agreement. And since demand was so high at the time, Prime told Refresco that that they anticipated needing, quote, spot contracts for production from other Refresco facilities from time to time. So the parties also worked toward a master supply agreement, or MSA, to facilitate future spot contracts for Prime products in other Refresco facilities. So the Truesdale agreement was signed on April 3rd, 2023, and Refresco immediately ordered customized equipment from third-party manufacturers in Europe. The agreement contained a provisional deadline for starting production on the dedicated line, and the last line says that the provisional deadline could be changed as agreed by the parties. And Refresco alleges that on June 12, 2023, the parties changed the deadline for the dedicated line. The changes were apparently discussed in a phone call and then memorialized on a spreadsheet, which said, quote, the dedicated line in Truesdale would be ready for startup in March-April 2024. The revised date was necessary because the European manufacturer of the equipment needed more time. So in this exchange, you can see how business relationships can gradually break down. Refresco says an email attachment contained a new date for commencement of the dedicated line, but Prime did not respond with a clear message that it agreed to the new deadline. Refresco continued to make plans for the dedicated line, but Prime seemingly did not object. And the agreement obligated the parties to keep working on the MSA, which was supposed to be done by October 1st, 2023, but Prime didn't give feedback on the MSA until the deadline passed. And by the spring of 2024, the dedicated line was just about ready for production, but when Refresco told the defendants that they needed to know Prime's orders for April and May, the Prime defendants said that they would have an estimate by the end of the day, quote, but they did not provide the requested forecast that day or ever. And after 3 weeks of silence, Prime's manager of external manufacturing told Refresco that, quote, the decision was made to not move forward with the incubation or flavor qualification at Truesdale. That is a roundabout way of saying that the deal is dead. Sorry, not sorry about the new dedicated line. Now, Refresco says that the reason Prime canceled the deal is because it realized that a slowdown in sales of their Prime hydration products likely was not just seasonal, that those sales, which had slowed in early winter, were not picking up as spring approached, as defendants had expected. Prime claimed that the Truesdale agreement expired on its own terms because the parties couldn't come to terms on the master supply agreement. That would be a fairly weak explanation, since the main reason for the business relationship was to get a dedicated line that would allow Refresco to fill massive orders. The more likely scenario is that Prime decided not to perform on its obligations because sales of Prime dramatically slowed down. So Refresco sued for breach of contract, promissory estoppel, and equitable estoppel. Refresco argues that the Truesdale agreement was binding on the parties as of April 3rd, 2023, and that it fully performed on its obligations under the contract, and Refresco says it sustained damages in the amount of $67 million. Now, the $67 million damages request is pretty interesting because now yet a third company claims that Prime can't pay its bills. Agrovana is a Massachusetts-based importer, which says it has provided over $70 million, surprisingly close to the $67 million, worth of ingredients to Prime since 2020. Agrovana says it has a contract with Prime for more than $32 million of product for the first half of 2024, but Prime stopped paying its bills and eventually refused to accept deliveries. But Prime contends that the products were defective. In the complaint, Agrovana alleges that Prime failed to pay for products and used, quote, deceptive acts and practices to avoid paying for products it had ordered in binding purchase agreements. And in a story you've probably heard before, the company blames Prime's, quote, inability to sell their product at the rate they projected for the alleged breach of contract. So don't be surprised if Logan Paul tries to flee the country, and if he does, he'll definitely need a good data plan to upload his videos while he's on the lam, which he can do with today's sponsor, Saley. Because Saley is an incredible new eSIM service app from Nord Security. Because if you've ever been lost abroad or badly need an internet connection with no Wi-Fi in sight, you'll understand what a difference a local SIM card can make. I'd never travel without one. Because an eSIM provides an internet connection wherever you travel and saves you a ton of money on roaming fees. And you can buy the data you want. Saley lets you choose from multiple affordable eSIM plans in over 150 countries. You can get tons of data and never have to worry about your tourist photos uploading in the background eating up all of your data. Not that that's ever happened to me. But I recently traveled to Japan, as you may know if you watched my reaction to Ace Attorney with a real Japanese lawyer. I was in Japan for 2 weeks, and getting an eSIM was the best decision I ever made. If you've ever tried to use the Tokyo subway without Google Maps, you know how important it is to have good internet service. And while all my friends were dealing with roaming fees and having their cellular data throttled, I could still navigate and plan daily activities while using ultra-fast internet wherever I went. I could even use my phone as a hotspot. Plus, with the Saley app, getting an eSIM couldn't be simpler. You just buy a plan and activate it, all on the Saley app or website. And once you've got it activated, you're good to use the internet wherever you go without needing to pop into a cafe and pray they have Wi-Fi. And of course, no waiting for a physical SIM card or having to switch one out. And all Saley eSIM plans are compatible with iOS and Android devices. And of course, an eSIM with Saley means there's no need to wait in line at a local airport to get a local SIM, and an eSIM can be installed only once, eliminating the need for users to install a new eSIM for each country. So you're covered virtually wherever you're going. So click on the link below or use the code LegalEagle to get an exclusive 50% off your first purchase. A Saley eSIM really is a traveler's best friend, and it's the best decision you can make before going to another country. So click on the link below or the one that's on screen right now to get 15% off. After that, click on this link over here for more Legal Eagle, or I'll see you in court. If Elon Musk is in the news, it's usually for one of three reasons. He's announcing a Tesla product that will never materialize, he's revealing the existence of another child, or he's pretending to buy a company and then backing out. Well, Tesla doesn't have any new products, he's up to 10 kids that we know of, so Elon Musk now wants to back out of his purchase of Twitter. Although some headlines said Musk cancels Twitter deal, that's not quite accurate. Musk has informed Twitter that he believes that the company is in breach of the acquisition agreement, and that he therefore will no longer perform the contract by purchasing the company. Twitter, on the other hand, says that it will sue to force Musk to buy the company at the original sales price. So this raises all sorts of questions. Can Elon get out of the deal because of bots? Can Musk pay $1 billion to cancel the contract? And if Twitter sues, can a judge force Musk to go through with this multi-billion-dollar deal? So how did Elon Musk find himself in this situation? Well, Musk is an avid/obsessed Twitter user. In early 2022, Musk initiated conversations with Twitter bigwigs and started buying Twitter stock. In February and March, Musk accumulated over 9% ownership of Twitter's common shares without formally disclosing his interest in a potential purchase, which was a violation of SEC rules. The SEC mandates that anyone who acquires more than 5% of the company's common shares has to disclose those holdings within 10 calendar days. Musk finally signed his filing 21 days after March 14th, the date his stake surpassed 5%. Now, after accepting and then rejecting a seat on Twitter's board of directors, Elon Musk made an offer to purchase Twitter for $44 billion. After a bunch of back and forth, Twitter agreed to sell if Musk could come up with the financing, eventually settling on a purchase price at $54.20 a share, which is entirely possible to be a 420 joke. Now, for reasons I won't go into, Musk styled the deal as a merger with a specially created company. So if you hear the term merger agreement, you can just think of purchase agreement. And on April 25th, Twitter and Musk announced a joint agreement. Quote, "Free speech is the bedrock of a functioning democracy, and Twitter is the digital town square where matters vital to the future of humanity are debated." Musk also said, quote, "I also want to make Twitter better than ever by enhancing the product with new features, making the algorithms open source to increase trust, defeating the spam bots, and authenticating all humans." But on May 15th, Musk started trying to backtrack on the deal. He tweeted that he was putting the deal on hold because he believed that more than 5% of Twitter's user base was made up of bots. A bot in this context means an automated account that isn't linked to a real person. Now, Twitter gave Musk more information about bots, but on July 8th, Musk told the SEC that he was exercising his right to terminate the contract. Twitter fired back that it will sue Musk to have him buy the company. So, can Musk end the contract, or can Twitter sue him for damages? Well, everything hinges on the contractual language that Musk says gives him the right to terminate the deal. So let's look at the letter that Musk sent to the SEC claiming to back out of the deal, and let's look at the contract provisions to see what rights are afforded. Now, mergers and acquisitions transactions often involve the disclosure or transfer of personal data from a seller to a purchaser. This may include all data about the target company and its assets, like data about employees, customers, users, and contractors. Now, one point of clarification here, this is not due diligence. Due diligence is something you do before you enter into a merger or acquisition agreement. But in this case, Musk didn't do very much due diligence. He signed the merger agreement without having access to much inside information from Twitter. Here, Musk says that he is terminating the contract because Twitter violated its obligations to provide him with access to information that is required under the contract. But crucially, this is not information for due diligence purposes. The time for due diligence is long over. It was over the second that Elon Musk signed the merger agreement. But at any rate, Section 6.4 of the merger contract is entitled Access to Information Confidentiality. This is the clause that Musk says Twitter breached, which states, quote, "Upon reasonable notice, the company shall cause each of its subsidiaries to afford to the representatives of parent reasonable access at parent's sole cost and expense in a manner not disruptive in any material respect to the operations of the business of the company and its subsidiaries, to the properties, books, and records of the company and its subsidiaries, and shall cause each of its subsidiaries to furnish promptly to representatives all information concerning the business, properties, and personnel of the company and its subsidiaries as may reasonably be requested in writing in each case for any reasonable business purpose related to the consummation of the transactions contemplated contemplated by this agreement. Now, that is lawyer speak for Twitter must provide Musk with company information. And there are all sorts of caveats. It must be related to a business purpose. Query whether Musk's requests are related to a business purpose or to screw over the business. It's hard to say. But Musk's legal team has said that, quote, Twitter has not complied with its contractual obligations under Section 6.4. Quote, for nearly 2 months, Mr. Musk has sought the data information necessary to make an independent assessment of the prevalence of fake or spam accounts on Twitter's platform. This information is fundamental to Twitter's business and financial performance and is necessary to consummate the transactions contemplated by the merger agreement because it is needed to ensure Twitter's satisfaction of the conditions to closing, to facilitate Mr. Musk's financing and financial planning for the transaction, and to engage in transaction planning for the business. So according to Musk's lawyers, Twitter breached its contractual obligations to close the deal. The centerpiece of the letter is that Twitter misrepresented the number of bots and refused to give Musk information that would identify the true number of bots on the platform. Though the lawyers couched it very carefully, quote, preliminary analysis by Mr. Musk's advisors of the information provided by Twitter to date causes Mr. Musk to strongly believe that the proportion of false and spam accounts included in the reported MDAU count is wildly higher than 5%. Now, that is not a factual claim about anything except what Elon Musk personally believes, which is a very sneaky way of avoiding an actual factual claim that could subject the lawyers to a little bit more scrutiny and the Musk in general to more liability. But let's hear about it from the man himself. Elon went on a podcast to explain that Twitter has so many bots that it makes Twitter a totally different company than the one he thought he was buying. Quote,
if they in fact have been vociferously claiming less than 5% of fake or spam accounts, but in fact it is 4 or 5 times that number, or perhaps 10 times that number, this is a big deal. It's not this. It's sort of like if you said, okay, I agree to buy your house. You say the house has less than 5% termites. That's an acceptable number. But if it turns out it is 90% termites, that's not okay. It's not the same house.
Now, if Twitter is 90% bots, then Elon Musk might be correct for reasons that we'll discuss in a moment. But is Twitter 90% bots? Probably not. But let's talk about Twitter's obligations. Twitter responded to Musk by giving him information about how it estimates the number of fake accounts. There's a long Twitter thread by the Twitter CEO that explains where the calculations came from. He said the 5% estimate is based on, quote, multiple human reviews in replicate of thousands of accounts that are sampled at random, consistently over time from accounts we count as MDAUs. Now, Twitter claims that its human review process uses both public and private data, like IP addresses, geolocation, and other factors to make a determination about whether an account belongs to a real person. Musk infamously responded to this thread with a simple poop emoji because that is the level of discourse that we face here. But Twitter eventually caved to Musk's demand for more information by giving him information about every single tweet in the Twitter universe. This has been referred to as the Firehose API, a stream of every tweet that's been sent. This dataset includes records of user tweets, the devices those users tweeted from, and real-time API data. And despite receiving this information, Musk says that he couldn't perform the analysis he wanted to, which may not be Twitter's problem. But his lawyers identified 5 more categories of stuff that they wanted related to user accounts. But the bottom line here is that Twitter probably gave Musk all the data he could reasonably be entitled to, and the contract probably doesn't require more of that. But there is another wrinkle here that deserves discussion, because even if Twitter underestimated the number of bots on the platform, Musk still doesn't have the legal right to cancel the agreement, because not all misrepresentations give Musk the right to back out. Now, in a normal contract, a material misrepresentation could absolutely give rise to canceling or terminating a contract. But this is a different kind of contract because people don't like to enter into these merger agreements and then have the possibility of backing out. And this contract would only be breached if the misrepresentations had a, quote, material adverse effect. Now, the phrase material adverse effect is a term of art used in mergers and acquisitions law. It's usually defined in the contract in a very long paragraph, and here the language has been interpreted several times by Delaware Delaware courts. We'll talk more about why Delaware later on, because that's the whole thing in and of itself. But in Delaware, there is a high standard for showing a material adverse effect. The burden of proof is usually on the buyer. Usually material adverse effect is invoked when the target company starts having significant performance problems. But even if a company's performance is in decline and is dramatic, Delaware courts generally say that the time period needs to be measured in years, not just a few bad months. And as far as I can tell, Delaware courts had never found a misrepresentation to give rise to a material adverse effect until 2018 in a case called Acorn versus Fresenius Kabi AG. The Delaware court summarized the buyer's burden of proof. Quote, "A buyer faces a heavy burden when it attempts to invoke a material adverse effect clause in order to avoid its obligations to close. A short-term hiccup in earnings should not suffice. Rather, the material adverse effect should be material when viewed from the longer-term perspective of a reasonable acquirer. In the absence of evidence to the contrary, a corporate acquirer may be assumed to be purchasing the target as part of a long-term strategy. The important consideration, therefore, is whether there has been an adverse change in the target's business that is consequential to the company's long-term earnings power over a commercially reasonable period, which one would expect to be measured in years rather than months." The buyer in Acorn was able to demonstrate that the magnitude of the change in performance was material, and this poor performance lasted for over a year. This precedent probably isn't very helpful to Musk's claim that spam accounts mean that Twitter is dramatically overstating its performance in ways that could impact Twitter's profitability down the line. In fact, one could argue that if there are more bots than they know of, then its profitability can only go up even further, because he'll get rid of the bots and make it even more profitable per user. And this is especially true since Musk said he wanted to acquire Twitter to improve the product by eliminating the bots. The SEC filings include voicemails by Musk where he presses Twitter to get the deal done quickly so he can fix the spam accounts and make the company more profitable. Musk then sent a voice message saying, quote, "If the deal doesn't work, given that I don't have confidence in management, nor do I believe I can drive the necessary change in the public market, I would need to reconsider my position as a shareholder. This is not a threat, it's simply not a good investment without the changes that need to be made." So even though Musk was at the time the company's top shareholder, he didn't think the stock was a good investment unless changes were made. He then offered Twitter a share price that was significantly above its value. In other words, Elon Musk made it clear from the outset that his interest in Twitter had nothing to do with its current profitability. And he knew that there were too many bots. He said he wanted to buy Twitter to prove a point about free speech, and he said he wanted to make it a better product by authenticating users, eliminating spam, and adding an edit button. So to sum it up, it looks like Twitter has a pretty good argument that they gave Musk all the information that he needed and was entitled to. And further, Twitter can certainly argue that number one, the bot numbers aren't wrong, but even if they were, it's still not a material adverse effect. If the bot numbers are 7% instead of 5%, that's probably not material. Though it's also probably important to note that one reason that Musk and his lawyers have couched this as a failure to provide info instead of focusing on claims of misrepresentation is that the misrepresentations are covered by the material adverse effect standard, whereas the obligations of the company found in the covenants are generally considered material. So if they breached their obligations under the covenants, they have a better chance of getting out of the deal itself. Additionally, Musk's lawyers also claim that Twitter failed to run their business in the ordinary course of business by firing 2 key employees and losing others in violation of Section 6.1 of the merger agreement. That section of the contract requires Twitter to seek and obtain consent before deviating from its obligations to conduct its business in the ordinary course and preserve substantially intact the material components of its current business organization. And this is a very common term you see in these kinds of agreements. The reason is obvious. When you're buying a company, you want to make sure that that company continues in more or less the same vein than it started, and it doesn't completely change their business while you're in the process of buying it. And here, Twitter fired its revenue product lead and the general manager of consumer and other employees to it, possibly because Elon Musk was buying the company. So Musk said that he objected to Twitter firing many talent acquisition employees and that he doesn't like Twitter's hiring freeze. Quote, "The company has not received parents' consent for changes in the conduct of its business, including for the specific changes listed above. The company's actions therefore constitute a material breach of Section 6.1 of the merger agreement." Now, it is very rare for deals to fall apart over these kinds of obligations. Number one, Twitter legally can't force anyone to stay, not since the 13th Amendment was passed. And additionally, sometimes as a company, you need to be able to terminate people. That happens in the regular course of business. So we'll see if there's any hay here, but it seems unlikely. So let's talk about what's going to happen in the ensuing litigation. Nothing is certain in litigation, but based on the facts of this case, in terms of the legal arguments, I'd much rather be Twitter than Elon in this particular situation. Now, normally when you're talking about a breach of contract and contract damages, you're talking about expectation damages. The party that didn't breach is entitled to be where they expect it to be after the contract was consummated. And you measure that by taking, in this case, the promised price, subtracting the current price of the company, and the delta is the amount that would be necessary to compensate you for where you expected to be. But here, the parties negotiated a bilateral $1 billion termination penalty. They considered that Twitter might get a better offer and might want to cancel this deal so they could go with the better offer. And they also considered that Musk might just, Musk everything up. But here, this termination provision is functioning like a liquidated damages provision. It sets the damages at $1 billion. Now, I suspect that if Elon Musk could get out of this deal by just paying $1 billion and walking away, he would probably take that deal and just walk away. But here's where things get really, really sticky, because Section 9.9b of the merger agreement gives Twitter the right to sue Musk for specific performance. Now, that is a legal term of art, but that basically means that Twitter can sue Musk and it can seek an injunction from the court forcing Musk to close the deal. Now, that is particularly complicated here because we are talking about a deal worth tens of billions of dollars. And it's also complicated because the deal requires outside financing from several banks. But the way that those agreements are written, the banks don't have a whole lot of outs here. Now, in law school, they teach students that specific performance is very rare, and it is. Courts generally aren't in the habit of forcing you to do something that you don't want. See, for example, the 13th Amendment. But it most often happens with real estate because it's thought that, at least legally, each piece of real estate is a unique thing that can't be compensated purely by money. But when you're dealing with contracts, courts would much rather make people pay money and go their separate ways. However, it happens more frequently in the context of mergers and acquisitions. Delaware courts have been known to order specific performance in just such a situation as this. Although it's more common for buyers to try and force specific performance, Delaware courts agree that sellers in the M&A context also have the right to force the sale to completion. So this is what happened when a company called IBP, the nation's top beef distributor, entered into a merger agreement with Tyson Foods, the nation's leading chicken distributor. Both companies performed poorly after the merger agreement was announced, and Tyson's had buyer's remorse. It tried to terminate the agreement, but IBP sued for specific performance. And in addressing whether a seller has the right to sue for specific performance, the court found no, quote, compelling reason why sellers in mergers and acquisitions transactions should have less of a right to demand specific performance than buyers. So the court concluded that Tyson had to go through with the purchase. The court said that even figuring out the right measure of cash damages would be too hard since the amount was presumably huge. The court said that specific performance was doable since during trial, Tyson's admitted that it just wanted a lower price and that the acquisition was still a good strategy for the company. The court also said that the shareholders would be better served on the whole by a specific performance remedy rather than a large damages award that did nothing but cost Tyson a large amount of money. And now I need to explain some trivia about the Delaware Courts of Chancery, where this case is going to end up. If you've been paying attention to litigation, you often hear people say it'll take years to resolve anything, and that's usually the case. That is not the case in the Delaware Chancery Courts. The Delaware Chancery Courts are basically business courts on steroids. They handle mergers and acquisitions for breakfast, and Delaware made a name for itself by being the most business-friendly state in the country. And the Delaware Chancery Courts have a specific expertise in dealing with these enormous business disputes. And they are fast. This could end up being resolved in months rather than years. And while the numbers are very high, the dollar amounts are very high, this is not a particularly complex case. In fact, Elon Musk is incredibly online, so many of the statements that he has made are public and will absolutely be used against him. So we'll probably have an answer to this question pretty quickly. And at base, the litigation outcomes are pretty stark. $1 billion in damages or force Musk to pay $44 billion to acquire a company he doesn't want. Now, in reality, depending on how litigation goes, I'm sure all of the parties will probably negotiate something in between. Maybe a bigger fee that lets Elon walk away, or maybe a lower price and he consummates the deal. It's entirely possible that everything was just posturing for him to get a better deal in the long term. Or maybe Elon never wanted Twitter in the first place. Who knows? But the important thing is that lawyers are going to get paid. And speaking of which, there is the breaking news that Twitter has indeed sued Elon Musk for one count of breach of contract. The company asked the Delaware Court of Chancery to enjoin Musk from further breaches of contract, to compel him to fulfill his legal obligations, and to compel consummation of the merger upon satisfaction of a few of the outstanding conditions. Now, maybe it's just me, but I find this particular complaint to be a pretty hilarious document. You can effectively put whatever you want into a complaint. It's your opportunity to tell your side of the story, and Twitter is doing just that. But it also just savages Elon Musk using his own statements and fills in quite a bit of the story. And it covers exactly what you would expect, that Musk is in material breach of the merger agreement. Twitter alleges that Musk didn't uphold his obligations, including financing, public disparagement of the company, and misuses information in the whole, backing out of the deal thing. But it also includes interesting tidbits like Musk didn't even read the information and reports that Twitter gave him, even though he's complaining about not having enough information. And Twitter alleges that he can't avail himself of the $1 billion termination fee and must specifically perform. He must consummate the deal for $44 billion. But given that this is Elon Musk, this is only the beginning of the craziness, and you'll be able to read all about the future antics in today's sponsor, Morning Brew, because that is my favorite way to catch up with pop culture and the news. I've actually been subscribed to Morning Brew for forever. It's one of my absolute favorite newsletters, and I'm thrilled to tell you why, because if you didn't know, Morning Brew is a daily newsletter delivered Monday through Sunday. It gets you up to speed on business, finance, tech, and law in just 5 minutes. And it provides a fantastic quick survey of the most important issues while being witty, irreverent, and informative. It's really, really funny. And did I mention it's completely free? This week I learned all about the James Webb Space Telescope, the continuing destruction of my stock portfolio, and the continuing destruction of the Texas power grid, which apparently doesn't work in the winter or in the summer now. Morning Brew is basically exactly the mix of news that I'm actually interested in, and stuff I didn't even know that I wanted to know about. And it's all written in a hilarious style. Morning Brew is one of the few emails that I actually open every single day. So, Legal Eagles, this one is a complete no-brainer. Morning Brew is completely free, and it takes less than 15 seconds to subscribe. Just click on the link that's on screen right now or in the description to get Morning Brew for free. And not only will you get a newsletter that you'll actually read, you'll actually help out this channel too. So click on the link below to get Morning Brew right away. And after you sign up, you should click on this playlist for more Legal Eagle, or I'll see you in court. Happy Saturday! Now send me a list of 5 things you did this week or you're fired. No, I'm not going to read all 4 million emails, but I'm so obsessed with efficiency that I'm going to cause millions of government employees to waste their entire workday trying to figure out 1, if you need to respond, and 2, what you can possibly say while not violating government secrecy laws or other ethical obligations. Yes, I'm a genius. On Saturday, February 22nd, the Office of Personnel Management, or OPM, sent an email to federal employees instructing them to respond with 5 things they accomplished last week, or else they would lose their jobs. When Musk bought Twitter for $44 billion, he sent a similar email to Twitter employees, demanding that they send him screenshots of their most salient lines of code. Musk then fired thousands of them, leading to dozens of lawsuits, all of which he's lost so far, and a diminished user experience at Twitter, to put it lightly. And now that Elon Musk has purchased the US government for a much lower price, he got to work making America more miserable for everyone, but especially government employees. Now, Musk's ostensible mandate is to make things more productive and efficient, and what better way to do that than by giving employees busy work and new bureaucratic puzzles to solve? It's not like they've got anything better to do, like, I don't know, making sure planes don't collide in midair, monitoring the transmission of avian flu to humans, and preventing people from dying while climbing the Grand Canyon. That stuff can wait. Now name 5 things you did last week, losers. Now we still don't know all the repercussions of the email blast, but as you'll see, there's a very interesting legal twist. And it seems that the government's representations in court are finally coming back to bite them. And in fact, one lawsuit that was filed long before the email blast went out might be the reason that people don't get fired for ignoring it. And in another twist, the person who filed that lawsuit is someone that you've probably seen on this channel before. But let's take a step back. When Doge employees took over the Office of Personnel Management in January, they set up a new email system that let the OPM email all federal employees through a single distribution list. The new system was called the Government-Wide Email System, or I'm assuming it's called the GWIZ. It sends emails to federal employees through the email address hr@opm.gov. Now, I'm new to American politics, so I assume that everyone on both sides of the aisle is totally cool with an unauthorized email server. But storing private and classified information on an unsecured server is a big security risk. And we don't know where the OPM server is physically located or who built the system, but it seems the system is now retaining information about every employee of the US executive branch. And it seems to be going far beyond federal employees. It appears to be retaining information about every person with a .gov or .mil email, which is a much bigger set. And there's also evidence that employees of the judicial branch, including lifetime appointed federal judges, are also getting the emails. Now, civil servants are worried that their personal information is not secure. They say, quote, standard email is not encrypted, and it is common practice among hackers, including hackers affiliated with hostile foreign services, to begin attempting to access a new US government device as soon as they learn of its deployment. Now, sure, that sounded like a big problem, but Elon Musk wasted no time in using the system to send an ultimatum to federal workers. On January 28th, OPM sent an email with the subject line "Fork in the Road" to roughly 2.3 million government employees. And as we talked about at the time, the email rolled out a deferred resignation program that really wasn't a resignation program, where people could stay on until September 30th working remotely with pay and benefits, but they still had to do their own jobs. And the email instructed employees to respond by February 6th. Now, it was easy to see Elon Musk's hand in this because he did the exact same thing when he purchased Twitter. Musk sent an email with the subject line "Fork in the Road" and gave Twitter employees 24 hours to decide if they wanted to work for him or quit. And Musk eventually fired about half of Twitter's workforce. But as Elon Musk soon found out, sending an email to everyone connected to the government is not the same as sending a company-wide email. Federal employees have civil service protections, and they filed several lawsuits challenging the legality of the deferred buyout program. And for more information about the Fork in the Road debacle, you can check out the video that we did with Liz Dye. But undeterred by lawsuits, on February 22nd, Elon Musk tweeted that, quote, consistent with President @real Donald Trump's instructions, all federal employees will shortly receive an email requesting to understand what they got done last week. Now, if it took you a second to parse whatever requesting to understand means, don't worry, it took me a second as well. I think what he meant to say is they'll get an email asking what people did last week. Now, 2 hours later, the OPM sent employees an email instructing them to respond with 5 things that they accomplished last week. Quote, please respond to this email with approximately 5 bullets of what you accomplished last week and CC your manager. Please don't send any classified information, links, or attachments. Deadline is this Monday at 11:59 p.m. Eastern Standard Time. Now, this was yet another email modeled on Musk's Twitter takeover. When Musk purchased Twitter, he told the employees to, quote, email him a bullet point summary of what your code commits have achieved in the past approximately 6 months, along with up to 10 screenshots of the most salient lines of code. That email was a prelude to mass terminations. And federal employees were understandably confused. The email was from the random HR address rather than their supervisors. The email itself did not say what would happen if employees missed the 11:59 p.m. deadline. And in a contradictory fashion, Musk's tweet warned them that failure to respond will be taken as a resignation. So did they have to respond or not? What happens if all of your work is classified? How are you supposed to summarize that? Well, apparently when you move fast and break things, nobody knows what's going on. For example, quote, officials at the Departments of Defense, State, Homeland Security, and Energy told workers not to respond. But leadership at the Cybersecurity and Infrastructure Security Agency and the Federal Emergency Management Agency, which are both housed within DHS, told their employees to answer the email. Treasury, Veterans Affairs, Commerce, and Interior instructed their employees to respond, but warned them not to share any classified information. The Department of Health and Human Services, which is now run by a guy with a legal brainworm, had no idea what was going on. At first, supervisors told staff to reply, but just hours later, the agency backtracked. On the following Sunday night, HHS sent an email asking employees to pause responses pending additional guidance. And the HHS acting general counsel said, quote, I'll be candid with you. Having put in over 70 hours of work last week advancing administration's priorities, I was personally insulted to receive the below email. And according to the AP, he was concerned that some agency employees could not discuss their work because of attorney-client privilege. One day later, HHS sent a third email, quote, there is no HHS expectation that HHS employees respond to OPM, and there is no impact to your employment with the agency if you choose not to respond. And HHS said that if anyone wanted to respond, they should not identify other HHS employees they worked with, matters they are working on, or specific grants or contracts. Quote, assume that what you write will be read by malign foreign actors and tailor your response accordingly. And I assume by malign foreign actors, they mean President Donald Trump. Speaking of whom, President Trump, ever a beacon of clarity, insisted that federal workers were required to answer Elon's 5 Things email.
What he's doing is saying, are you actually working? And then if you don't answer, like you're sort of semi-fired or you're fired, because a lot of people are not answering because they don't even exist.
But while Trump was defending Elon's email, the OPM was contradicting him. OPM told federal employees that, quote, any employee response to the email is voluntary and that not responding will not be considered a resignation. Meanwhile, OPM's acting director, Charles Ezell, was silent about whether employees who didn't respond had resigned. Ezell said, quote, agencies should review responses and evaluate non-responses, and that agency leaders, quote, may exclude personnel from this expectation at their discretion. Ezell put the pressure on supervisors to decide whether to fire people. Quote, agencies should consider any appropriate actions regarding employees who fail to respond to activity accomplishment requests. It is agency leadership's decision as to what actions are taken. But the Monday deadline came and went, and Musk fumed about it on Twitter. Quote, subject to the discretion of the president, they will be given another chance. Failure to respond a second time will result in termination. So instead of clarity, we got a whole bunch of chaos. However, a lawyer emerged to save the day. Now, if you're mishandling troves of government data and lying to the courts about it, you'll probably want a good lawyer. But if you want a great lawyer, let my law firm, the Eagle Team, help. If you've gotten in a car crash, suffered a data breach, whether Elon Musk was at fault or not, especially if you got one of those data breach letters saying that your information might have been leaked, or dealing with a workers' comp or social security issue, maybe because you got fired by the government, we can represent you or help find you the right attorney. It's so important to talk to a lawyer right away so you can maximize your recovery. And we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. Now, back on February 5th, Kel McClanahan with the National Security Counselors filed a lawsuit accusing the OPM of setting up an unauthorized, insecure server to send mass emails without conducting a privacy impact statement as required by law. And additionally, you might have also heard of the illegal email server. Well, our friend and fellow attorney Kel McClanahan filed a lawsuit against OPM on behalf of government employees who received potentially illegal and unsecured emails from Elon Musk and his Doge team. The 7 plaintiffs are either employees or affiliates of various government agencies or organizations. They allege that OPM, working with Doge, set up an unauthorized server built by a commercial entity to conduct email blasts without providing a privacy impact assessment for it. The lawsuit asserts that OPM used the server to send several test emails to workers across the government, as well as the fork in the road emails, which offered deferred resignations to federal employees. Now, under the E-Government Act of 2002, federal agencies are required to complete a Privacy Impact Assessment, or PIA, before initiating any new collection of personally identifiable information, PII, using information technology. This assessment must evaluate what information is collected, why it is collected, how it is to be used, with whom it is to be shared, and how it will be secured. Additionally, agencies must ensure that the Chief Information Officer or an equivalent official reviews and signs off on it. The appropriate government official must make the PIA publicly available through their website, the Federal Register, or other means. But here, the OPM allegedly did not conduct a PIA for the new email system and the server in question. McClanahan apparently discovered the issue when an OPM employee posted information to a union chat and someone circulated the message on Reddit. And the Reddit message warns of dire circumstances within OPM. Quote, an on-prem, on-site email server was set up. Someone literally walked into our building and plugged in an email server to our network to make it appear that emails were coming from OPM. It's been the one sending those various test messages you've all seen. We think they're building a massive email list of all federal employees to generate mass RIF, reduction in force notices, down the road. The non-political civil servants here at OPM are watching helplessly as our government is being systematically dismantled bit by bit. Even the IGs are being fired to prevent them from investigating the numerous whistleblower complaints we filed. The message also discusses the resignation of OPM CIO Melvin Brown. The message said Brown, quote, was pushed aside just 1 week into his tenure because he refused to set up email lists to send out direct communications to all career civil servants. And the plaintiffs are concerned about the security of their PII being stored on an unknown server. They cited the infamous 2015 data hacks, which compromised the information of 21.5 million people, including sensitive data drawn from background checks. Quote, standard email is not encrypted, and it is common practice among hackers, including hackers affiliated with hostile foreign services, to begin attempting to access a new U.S. government device as soon as they learn of its deployment. Plaintiffs moved for a temporary injunction, declaring that the OPM's actions violate federal law, compelling the OPM to publish a legally sufficient PIA, and ordering the OPM to disgorge all improperly collected information. In response, the Trump administration opposed the TRO. They argued that the plaintiffs misunderstood the E-Government Act, and the government says that the act requires privacy impact assessments only for systems that deal with public information, whereas the OPM system only handles information related to federal employees. However, plaintiffs say that non-executive branch employees received some of the emails. For example, FedScoop reported that, quote, employees at the Library of Congress, which is a legislative branch agency, and thus outside the direct scope of the Trump administration's workforce actions, received a test email. The Trump administration denied that it was required to file a PIA, but filed one a mere hour before Kell's lawsuit went in front of a judge. So we thought we'd ask Kell McClanahan directly. So, Kell, what happened?
So what happened was that we were overtaken by events, as often is the case when dealing with these Trump actions, where we had filed a case when all we knew about the server was that it was sending out test emails. It was before they even sent out that fork in the road email. And then we filed a TRO a week later based on everything new we had learned about the system and said you need to shut it down until they do a PIA. Then, as you say, the day of their opposition to the TRO, they said, here's a shiny PIA that we just did. It's moot now, right? The judge said, well, you didn't say in your TRO motion or even in your complaint that they had to file a proper PIA. You just said they have to file a PIA. So I'm going to hold that this motion that you have filed is moot because they filed a PIA. However, if you want to argue that they filed a POS PIA, then you need to amend your complaint and file a new TRO. Do that tomorrow. And so we did that last night.
Now, the government alleges that the PIA requirement doesn't apply here. What do you say to that?
This is, first of all, just factually irrelevant and inaccurate. They did not collect information from just federal government employees. And that doesn't matter for whether or not you define federal government to be just the executive branch or the government as a whole. They collected it from everyone with a .gov or .mil address, which is more than just federal government employees. So it's just wrong. It doesn't apply. Number two is that prior to last year, the OMB guidance would have been entitled to, let's call it deference, perhaps even Chevron deference. And a whole bunch of people went and sued on behalf of Republicans everywhere to get rid of Chevron deference and say that judges can make decisions about whether or not they believe a law requires something, regardless of what the agency guidance on that says. And now they're turning around and saying, well, this agency guidance says that this does not apply. Therefore, ta-da, I found one weird trick. And that's nice. You're not entitled to Chevron deference anymore because you caught the car and you won that argument in Loper Bright. And it's up to the judge to decide if this applies to collections of information about people besides federal government employees. But then again, he might not because, as I said before, it's not just limited to federal government employees. And so this just falls flat.
What about the emails to the Library of Congress? Could they be construed as members of the public?
Well, they can, and they can also potentially be construed as federal government employees, depending on how you want to parse federal government. But even then, it doesn't matter because we know that legislative branch employees got this email. Judge Moss said in the hearing on Thursday that he got the email. And we've had wide reporting that judicial branch employees got the email. And I have clients who are contractors who got the email. And so even if you say that federal government employees applies to everyone in every branch of government, it does not apply to the contractors. It does not apply to the state of California employee who is one of my clients who got the email because she was in a program that partnered with a government agency. And so that's why she had a .gov email address. It just is an irrelevant point. These are a lot of arguments that are nitpicking based on the assertion that it only collected information about executive branch employees or maybe larger government employees. But once you knock that down, the whole house of cards falls.
Am I curious? Yes.
And what do we know about the OPM's PIA issued on February 5th?
All we know for sure is that it was done sometime between January 22nd, which was the day that Greg Hogan, the signatory, took over as chief information officer, because we know that Melvin Brown, his predecessor, refused to allow the government-wide email system to happen. It was also done sometime before February 5th, or including February 5th, because that's the day they filed it in my case, where they dropped it at 10 o'clock in the morning when we were supposed to have a status conference at 11 o'clock in the morning. So, that's not suspicious at all. It is more likely that it was done after I filed my temporary restraining order motion, but we don't have evidence of that. But what we do know is that even if they started writing it when they started doing the system, that's still only 2 weeks. You don't do a PIA for a major information system in 2 weeks. You do a PIA in, at best, 2 months, because it's complicated. Okay, fun fact. The reason that the OPM hack happened in 2014 was because the Chinese were very, very methodical and very, very patient. And they found an access point where they were able to spoof coming from opmsecurity.org, which fooled the system into thinking they were part of OPM. Then they sat there until they saw an opening, and then they stuck a person in there who could log in and be recognized by the system as an authorized individual. The system thought that that person was need to know as far as the access goes. So the fact that they are saying this system can only be accessed by people with the need to know is predicated on the idea that the only way to access the computer is by walking up to it and sitting down in front of it and typing into it. However, that is not how things work in cybersecurity, and even the net got that right. And so as long as they are sitting out here with this server with all of this information on it, the server doesn't know if you're sitting down in front of it or you're accessing it remotely. I guarantee you that some of these guys are accessing it remotely. And so what are we supposed to draw from this? What are we supposed to conclude by the fact that our security measures are, we make sure people can't get into the room where it's sitting connected to the entire network?
What do we know about exactly when this PIA was done?
PIAs take a long time to work on because they are important. And in fact, the law requires that the complexity of a system be commensurate with the complexity of the PIA. And when you have something like a major information system, as the law defines it, you have to be even more specific. So when you have that, and you look at the other PIAs that even just OPM has promulgated for its other systems, one of which is actually the Microsoft Office 365 information system that they use for all their communicating, you see these are very specific requirements, and these are very specific answers. They say who is doing what, why we decided on doing this, what security measures were considered, what we thought after we did the PIA, how we adjusted the way we used the system, et cetera, et cetera. Then you have this PIA. And this PIA, I want to make clear, I call a PIA so that every answer doesn't have to go with this document that purports to be a PIA. This is not a PIA. This is, as someone said a couple of days ago, a restaurant menu with PIA written across the top of it. It says things like, we don't need to do this because we are being very secure. How is the data being protected? It's being protected by protective measures. It does not give answers to any of the questions. Some of the stuff it says is factually just wrong, like we only collect information about government employees. Some of the information is extraordinarily misleading, and even if you accept that everything in it is truthful, it's still woefully legally insufficient.
Thanks for coming on, Kel, as always. And if you'd like to support the work that the National Security Counselors is doing, we'll leave a link for that down in the description. They receive a lot of their funding through private donation, and their work is more necessary now than it ever has been. Now, it seems that in response to the suit, OPM tried to conduct a privacy impact statement for the GWiz email system. The privacy impact assessment stressed that participation in the system was actually voluntary. Section 4.2 says, quote, "The employee response data is explicitly voluntary. The individual federal government employees can opt out simply by not responding to the email. And OPM acknowledges that some employees might not realize they aren't required to respond to these government emails. So the PIA concludes this risk can be mitigated, quote, by ensuring that any email sent using GWiz is clear by explicitly stating that the response is voluntary and by including specific instructions for a response. Which is super weird because none of that language was ever included in any of these emails. But the OPM argued that the PIA mooted the case, quote, because the agency has in fact published a PIA despite it not being required to do so, this case is moot and plaintiffs cannot establish irreparable harm. Problem solved? Well, that response convinced the judge to deny plaintiffs' motion for a temporary restraining order, but forcing the OPM to publish a PIA wound up accomplishing quite a bit actually because the OPM told the court that employees did not have to respond to these mass emails. OPM claimed that the government workers who had received emails from the email system had limited privacy protections, but OPM sent emails to people who were not within its jurisdiction, the executive branch. The 5 Things email even went out to some federal judges who obviously work for the judiciary and can't be fired by OPM. And according to an email from the director of the Department of Administrative Services for U.S. federal courts, quote, we understand that some judges and judiciary staff have received an email from hr@opm.gov. Please be advised that this email did not originate from the judiciary or the administrative office, and we suggest that no action be taken. So if any of these employees responded, they might now have standing to sue along with their executive branch counterparts. And since the emails went out to so many people who were not executive employees, plaintiffs filed an amended complaint expanding the proposed class to everyone with a government email address. And Cal has now moved for Rule 11 sanctions against the government. Under Rule 11C2, lawyers must give the opposing side 21 days to correct the offending conduct. And he asked the court to shorten the safe harbor period to just 5 days, and the judge agreed, so the motion is now on the public docket. And plaintiffs allege that OPM submitted false evidence to the court in an attempt to avoid a temporary restraining order. And the PIA asserts that the GWiz system only collected voluntary responses from federal employees, and the PIA reiterated this claim 5 times. However, as we just discussed, the system was actually used to gather responses from non-executive branch employees, including judiciary staff. Guidance from the president and some agencies indicated that responding was mandatory, and the court relied on this inaccurate information when denying the initial TRO. So according to the plaintiffs, quote, both of these actions demonstrate a clear lack of candor to the tribunal, and OPM and its counsel should be sanctioned for unreasonably multiplying the proceedings and violating the integrity of the court's process by entering statements into evidence which were known to be false and then citing them uncritically to the court to convince the court that OPM's actions were legal and that plaintiffs were not at risk of imminent harm. Now, in the wake of President Trump's executive orders, there have been a deluge of federal lawsuits that have been filed. I think over 100 at this point. But I believe that this is the first time any of the plaintiffs' lawyers have sought sanctions against the government. But given the representations that the government is making in court, I doubt this will be the last motion for sanctions. And here the motion cites 3 legal authorities for imposing sanctions. Rule 11 requires attorneys to ensure that filings are factually and legally supported and not presented for improper purposes such as harassment or delay. Plaintiffs argue that, quote, OPM and its counsel intentionally, unreasonably, vexatiously, and in bad faith entered a document containing false information into evidence and argued that the court should rely on the statements made in that document. Plaintiffs twice asked the court to grant a temporary restraining order, and both times OPM lawyers asserted the issue was moot because of the PIA. So this undoubtedly added expense and time to the litigation. And as plaintiffs point out, quote, OPM convinced this court to deny plaintiffs' first request for a TRO, force the parties to brief a second motion for a TRO, and are forcing plaintiffs to respond to a motion to dismiss, which is largely predicated on the fact that the invalid and inaccurate GWiz PIA is in the record. Plaintiffs argue that because OPM and its counsel knowingly submitted false evidence, misleading the court and prolonging the proceedings, the court should strike the PIA from the record, prohibit OPM from relying on the PIA at this stage in the litigation, order OPM's lawyers to file sworn statements regarding how much they actually know about OPM's representations, and grant the plaintiffs any other relief that would deter OPM from repeating the conduct. Now, the court hasn't ruled on this motion yet, but on Friday night, OPM updated the PIA, sent out another round of emails, and issued more conflicting guidance. It really does feel like Groundhog Day because the Department of Government Efficiency is making everyone do the same thing over and over and over again. But the updated PIA says that responding to the email system is voluntary, but, quote, the consequences for failure to provide the requested information will vary depending on the particular email at issue. OPM and the agencies then sent a second version of the 5 Things email. The subject line was, what did you do last week, part 2? The email directed employees to file a weekly response summarizing what they accomplished. Now, some employees received this email from their agencies, which could be a different strategy to moot the case, because there's probably nothing wrong with asking an employee to respond by email to their direct supervisor. However, some employees still received the email directly from OPM, and OPM made the situation more confusing by telling agency leaders they should send a copy of their response to OPM, and OPM didn't say what the agency planned to do with these emails. OPM did say, quote, agencies should review responses and evaluate non-responses. And once again, agencies are taking different approaches. This time around, the State Department told its employees they did not have to respond to the email, but the Defense Department said all civilians must respond to emails from Pete Hegseth within 48 hours. And over at DHS, employees were directed to send their responses to an email address at DHS. And once again, Elon Musk issued directives from his Twitter account, quote, the president has made it clear that this is mandatory for the executive branch. Anyone working on classified or other sensitive matters is still required to respond if they receive the email, but can simply reply that their work is sensitive. So responding is mandatory or discretionary, and the consequences are dire or non-existent. But with respect to the OPM lawsuit, the plaintiffs took a loss when the government denied the motion for a TRO, but they at least forced OPM to cough up a document that lawyers all over the country will now use against them. And while we don't have a permanent resolution in this particular case yet, the lesson here is that it's good to make the government go on record about what it's doing. And as for what OPM will do with the 5 Things email, the humor website McSweeney's predicted that the government will, quote, feed them to an AI which will flag any forbidden words like diversity and woman, so it can eventually be read by a racist Doge bro. And what do you know? NBC News has just reported that Doge will use AI to review all the responses. Now, OPM's blatant disregard for privacy and the need to protect people's personal data is just the tip of the iceberg. Leaks and data hacks are happening all the time, and when your private data gets compromised, it gets sold and resold all around the world by data brokers. Luckily, there are people out there who can help, and that's why we recommend signing up for today's sponsor, Incogni. You can use my link in the description of the code LegalEagle for an exclusive 60% off discount. Because Incogni removes your personal data from online data brokers by reaching out directly and forcing them to take your personal info down. If the data brokers resist, Incogni will take care of that too, because Incogni fights back. These data brokers are the reason why in the US you can search your name and find a bunch of websites that will give anyone your home address, phone number, and extensive history. It's shocking just how easy it is to find all this information. It also might be why you're getting so many spam calls lately, or even how someone might steal your identity. But Incogni is a great way to take back control of your data, increase your online privacy, and cut down on those annoying scam calls and emails that used to flood my voicemail and inbox. I've been using Incogni for years, and in that time you can see I've been on hundreds of lists, some of which had a high sensitivity score, meaning that the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns for me over the years and is processing dozens of others. If I were to try this myself, it would take hundreds of hours. So thank you to Incogni for saving me hundreds of hours and adding me to over 40 suppression lists. And the best part is Incogni will continue to conduct ongoing removals because even if the broker removes your data once, they can collect it again. Incogni makes sure that your personal information stays off the market for good. So if online privacy is important to you, give Incogni a try. If you click on the link that's on screen or down below, you can try Incogni risk-free for 30 days and get a full refund if you're not into it. But if you keep it, you still get the exclusive 60% off discount, so long as you use my link or the code LegalEagle, all one word. So after that, click on this link over here for more LegalEagle, or I'll see you in court. Imagine being picked up by ICE and told you're being deported, but not to your home country, but to a place you've never been before, a country where you don't speak the language, a country torn apart by war, and worst of all, you don't even get to argue your case in front of a judge before you're shipped off. This week, in a stunning shadow docket decision, the Supreme Court gave the green light for the U.S. to deport people to a third country, even while serious legal questions are still being litigated. And there was literally a plane waiting in Djibouti with detainees and customs officers on board while this played out in real time. And if you think this sounds like a due process nightmare, you're not wrong. And what makes this even worse is that the Trump administration openly flouted 2 district court orders not to remove people to South Sudan. And right or wrong, rather than backing up the district court judge who issued the orders, the Supreme Court basically told the Trump administration, hey, it's totally cool that you ignored the orders.
Thank you again. Thank you again. Won't forget. So good.
And they did this all on the shadow docket without writing a single word about why they allowed the government to proceed. So today we're going to break down what Georgetown law professor Steve Vladeck calls a disastrous Supreme Court decision. And if that man says it's disastrous, this is an actual 5-alarm fire, and explain what it means for immigration law, due process, and the limits of executive power. Now, on February 18, 2025, the Department of Homeland Security issued a policy directive instructing officers to review all cases of individuals previously released from immigration detention for redetention and removal to a third country, a country that differs from the countries of origin or citizenship. Now, a class of non-citizens with final removal orders sued DHS, challenging the government's practice of removing people to a third country without providing notice or opportunity to contest. Now, make no mistake, under 8 U.S.C. 1231, the government is allowed to remove individuals to several specified countries, such as their country of birth, last residence, or departure port. If none of those countries are viable, the statute allows the government to send the person to any country willing to accept them. Now, this class action did not challenge the government's right to remove people to third countries. The core issue was whether people facing removal to a third country have the right to notice and a chance to object if they fear torture or inhumane treatment to this country that they've probably never been to. These protections are known as cat relief under the Convention Against Torture. Non-citizens already have the right when the destination is the country originally named in the case. In other words, everyone agrees that when deportation proceedings begin and the government names the place that the non-citizen is intended to be deported to, that non-citizen has the right under immigration law to contest in front of an immigration judge the location of their deportation. Because it's often the case, especially with asylum seekers or refugees, that really terrible things could happen if they're deported to a specific country. But the question here was if that same protection applies when the government picks a different country after the removal proceedings are already over. And here, the district court judge, Brian Murphy, concluded that it does. He issued an injunction stating, quote, "The case presents a simple question. Before the United States forcibly sends someone to a country other than their country of origin, must that person be told where they are going and be given a chance to tell the United States that they might be killed if sent there? Defendants argue that the United States may send a deportable alien to a country not of their origin, not where an immigration judge has ordered, where they may be immediately tortured and killed without providing that person any opportunity to tell the deporting authorities that they face grave danger or death because of such a deportation. All 9 sitting justices of the Supreme Court of the United States, the Assistant Solicitor General of the United States, Congress, common sense, basic decency, and this court all disagree. Plaintiffs are seeking a limited and measurable remedy. One defendants have conceded in other proceedings is the minimum that comports with due process. Plaintiffs are simply asking to be told they're going to be deported to a new country before they are taken to such a country and be given an opportunity to explain why such a deportation will likely result in their persecution, torture, and/or death. This small modicum of process is mandated by the Constitution of the United States, and for this reason, the motion for class certification is granted, and the motion for preliminary injunction is granted in part. Now, despite that common sense decision from the district court, unfortunately only 3 Supreme Court justices agree that before the government deports someone to a new country where they may face torture, enslavement, or death, that person is entitled to notice and a hearing. And the majority made its decision on the shadow docket. The shadow docket refers to the Supreme Court's use of emergency orders and summary decisions that are issued without full briefing, oral argument, or signed opinions. And the Roberts Court has used the shadow docket more than any court in history. They have used it to make highly consequential decisions without full transparency. Now, this all gets a little bit technical, but at least 5 justices granted the government's request to lift Judge Murphy's stay. So in other words, what happened here is the district court, the trial court, issued this preliminary injunction temporarily preventing the government from removing these people without notice. Then the government appealed, and as part of that appeals process, sought to lift the preliminary injunction while things were being appealed to the Court of Appeals and eventually the Supreme Court. And the Supreme Court said, yes, while all of this is being appealed, that preliminary injunction is invalidated, which is usually a sign of what the Supreme Court would hold on the merits when it reaches them. And because of how the shadow docket works, we don't know if any of the Republican justices privately dissented, but declined to join the dissenting opinion. And in this case, the majority chose not to reveal their reasons for granting the stay of the preliminary injunction. The block paragraph simply says that the preliminary injunction is stayed, meaning it's not a final ruling on the merits. In effect, however, the order allows the Trump administration to deport anyone with a removal order to any country it chooses, regardless of the potential dangers, and without giving that person a chance to challenge that decision. Now, unlike the government, if you kidnap people and send them to a third country, you're going to want a good lawyer. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've gotten in a car crash, suffered a data breach, especially if you got one of those data breach letters saying that your information might have been leaked, or dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you understand your legal team, you need the Eagle Team. Now, Justice Sotomayor, writing for the 3 liberal justices, blasted the decision in a 19-page dissenting opinion. She started by reviewing the government's actions in this case, which included ignoring direct court orders. Quote, here, in violation of an unambiguous TRO, the government flew 4 non-citizens to Guantanamo Bay and from there deported them to El Salvador. Then, in violation of the very preliminary injunction from which it now seeks relief, the government removed 6 class members to South Sudan with less than 16 hours notice and no opportunity to be heard. The government's assertion that these deportations could be reconciled with the injunction is wholly without merit. Notice at 5:45 p.m. for a 9:35 a.m. deportation provided to a detainee without access to an attorney plainly does not afford that non-citizen with a reasonable time to seek relief. Even if the government's overnight notice had been adequate, moreover, DHS also did not provide the required meaningful opportunity to raise a fear of return under the convention. The affected class members lacked any opportunity to research South Sudan to determine whether they would face risks of torture or death there or speak to anyone about their concerns. Instead, they were left in their cells overnight with no chance to raise a claim and deported the next morning. The government thus openly flouted 2 court orders, including the one from which it now seeks relief. Even if the orders in question had been mistaken, the government had a duty to obey them until they were reversed by orderly and proper proceedings. That principle is a bedrock of rule of law. The government's misconduct threatens it to its core. And the majority has now sanctified the government's gross misconduct. Justice Sotomayor says this decision erodes the rule of law. Quote, "This is not the first time the court closes its eyes to noncompliance, nor I fear will it be the last. Yet each time this court rewards noncompliance with discretionary relief, it further erodes the respect for courts and for the rule of law." And she's right. All this deals with courts of equity, which I will simplify by saying non-monetary relief. This court issued an injunction that is an equitable remedy. And there's a saying that in order to receive equity, you must do equity. And here the government has engaged in manifest bad faith, ignoring court orders, and it's shocking that they can get away with their unclean hands. And one of the most troubling elements of the court's decision is the way it undermines the authority of district court judges. District courts are responsible for conducting thorough fact-finding, a responsibility that appellate courts have traditionally respected and deferred to. And time after time, even Trump-appointed judges have found against the administration after conducting thorough hearings. But the Roberts Court showed open disregard for the district court's work. As the dissent puts it, quote, "In matters of life and death, it's best to proceed with caution. In this case, the government took the opposite approach. It wrongfully deported one plaintiff to Guatemala, even though an immigration judge found he was likely to face torture there. Then, in clear violation of a court order, it deported 6 more people to South Sudan, a nation the State Department considers too unsafe for all but its most critical personnel. An attentive district court's timely intervention only narrowly prevented a 3rd set of unlawful removals to Libya. Rather than allowing our lower court colleagues to manage this high-stakes litigation with the care and attention it plainly requires, this court now intervenes to grant the government emergency relief from an order it has repeatedly defied. I cannot join so gross an abuse of the court's equitable discretion. Justice Sotomayor also noted a troubling pattern in the way Republican justices are interpreting irreparable harm. In federal court, as we've talked about a lot of times, to obtain a preliminary injunction, a party must typically demonstrate 4 factors: a likelihood of success on the merits, a likelihood of irreparable harm if the injunction is not granted, that the balance of the equities favors granting the injunction, and that an injunction is in the public interest. And the balance of equities requires the court to weigh the potential harm the moving party would suffer without the injunction against the harm the opposing party would face if the injunction is granted. And this ensures that the court only grants relief when it is fair and just to do so, preventing unnecessary or disproportionate harm on either side during the litigation. And Justice Sotomayor accused the majority of ignoring the concept of irreparable harm. Quote, "In light of the government's flagrantly unlawful conduct, today's decision might suggest the government faces extraordinary harms. Yet, even that is not the case. Rather, following a recent trend, the court appears to give no serious consideration to the irreparable harm factor. Without a showing that a stay is necessary to avoid irreparable harm, however, this court's midstream intervention is inexcusable. Besides the facially absurd contention that the executive is irreparably harmed by any time the court orders it temporarily to refrain from doing something it would like to do, the government has identified no irreparable harm from the challenged preliminary injunction. Instead, the government locates the source of its injury in the district court's efforts to provide relief to class members in South Sudan. That argument is misguided. First, the district court remedial orders are not properly before this court because the government has not appealed them nor sought a stay pending a forthcoming appeal. Second, the court adopted the narrowest possible remedy, allowing the government itself to choose whether it would return the class members to the United States or provide them with process where they are held. Finally, the government is in every respect responsible for any resulting harms. Had it complied with the preliminary injunction, no follow-up orders would have been necessary, nor would the government have faced a sudden need to detain criminal aliens abroad. It does not face such a need today, as it can return the non-citizens it wrongfully removed at any time. No litigant, even the government, may satisfy the irreparable harm requirement if the harm complained of is self-inflicted. Sotomayor also accurately pointed out, quote, "Given its conduct in these proceedings, the government's posture resembles that of an arsonist who calls 911 to report firefighters for violating a local noise ordinance." And the court obviously interpreted the balance of equities to favor the Trump administration, even though they have all the power and the migrants are the ones who are subject to removal orders that could face death. Justice Sotomayor does not mince words about the consequences of the court's decision. Quote, "For their part, the plaintiffs in this case face extraordinary harms from even a temporary grant of relief to the government. The government has made clear in word and deed that it feels itself unconstrained by law, free to deport anyone anywhere without notice or an opportunity to be heard. The episodes of noncompliance in this very case illustrate the risks. 13 non-citizens narrowly escaped being the target of extraordinary violence in Libya. OCG spent months in hiding in Guatemala. Others face release in South Sudan, which the State Department says is in the midst of armed conflict between ethnic groups. Only the district court's careful attention to this case prevented worse outcomes. Yet today, the court obstructs those proceedings, exposing thousands to risk of torture or death. And this is why the decision is so disturbing. Although the case will continue to plod through the courts until the Supreme Court makes a final decision on the merits, the stay means that Trump has the green light to send people to nations which practice slavery and torture. And somehow at least 5 justices believe that the balance of equities favors the Trump administration. But how could that possibly be the case? How is the government harmed if they can't deport people to foreign gulags without a hearing or minimal notice? This case isn't about the authority to remove people to third countries. The government does have that power under certain circumstances. It's simply about whether putative deportees have the right to notice of where they're going and an opportunity to contest that location, which are almost certainly rights that they have under current immigration law. But we don't know what the majority is thinking on this. They made a decision that may alter the lives of thousands of people, but they chose not to explain the reasons why, which is one of the most dangerous things about the shadow docket. And Justice Sotomayor expressed extreme concern that her colleagues are enabling the total destruction of the rule of law. Quote, "The Due Process Clause represents the principle that ours is a government of laws, not of men, and that we submit ourselves to rulers only if under rules. By rewarding lawlessness, this court once again undermines that foundational principle." Apparently, the court finds the idea that thousands will suffer violence in far-flung locales more palatable than the remote possibility that a district court exceeded its remedial powers when it ordered the government to provide notice and process to which the plaintiffs are constitutionally and statutorily entitled. That use of discretion is as incomprehensible as it is inexcusable. Respectfully, but regretfully, I dissent. And the impact of this ruling is honestly huge. It allows one of the government's draconian deportation schemes to move forward without delay. Now, during the Biden administration, the U.S. allowed about 1 million people to enter the country legally for humanitarian reasons. But the Supreme Court let Trump end the Cuban, Haitian, Nicaraguan, and Venezuelan humanitarian parole programs. And as a result, nearly 500,000 people must leave the country or face removal. And while that program existed, all of those people were in this country legally. And the court also allowed Trump to end protected status for around 500,000 Venezuelan nationals. In both of these cases, the court granted the administration a stay of lower court orders, halting the administration's efforts. Now those people can be placed in removal proceedings. But what's crazy is because of this particular ruling, they're in even greater peril. If an immigration court rules that they can't be removed to their country of origin, which they left because of a humanitarian disaster, the Trump administration could send them basically anywhere it wants to. South Sudan, Libya, El Salvador, or any third country, all without any notice or process whatsoever. And while the Supreme Court has been making these rulings on the shadow docket, lower court judges have been ordering the administration to return individuals who were deported in violation of court orders or deported in error. But now the Justice Department has no incentive to follow lower court orders, and the government is incentivized to just quickly send people wherever it can across the globe as quickly as it can. But regardless of your naturalization status, now is probably a good time to wipe the internet of all of your personal data. And this can literally be the difference between life and death. And it's not surprising. These data brokers vacuum up all your personal data from all corners of the internet and sell it to anyone who wants to buy it. But you can fight back and take control of your sensitive data from data brokers with the help of today's sponsor, Incogni. Because Incogni removes your personal data from online data brokers by reaching out directly and forcing them to take your personal info down. If these data brokers resist, Incogni will take care of that too because Incogni fights back. Now, Incogni scours the internet by itself, but they just launched a new feature called Custom Removals. If you find something else, it allows you to flag an unlimited number of sites where your data might be exposed, and you can have Incogni's privacy experts review and tackle the most uncooperative data brokers and people's search sites. But these data brokers are the reason why in the US you can search your name and find a bunch of websites that'll give anyone your home address, phone number, and extensive history. It's shocking just how easy it is to find all this information. It also might be why you're getting so many spam calls lately, or even how someone might steal your identity. But Incogni is a great way to take back control of your data, increase online privacy, and cut down on those annoying scam calls and emails that used to flood my voicemail and inbox. Now, I've been using Incogni for years, and in that time you can see that I've been on hundreds of lists, some of which had a high sensitivity score, meaning the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns for me over the years and is processing dozens of others. If I were to try this myself, it would take hundreds of hours. So thank you to Incogni for saving me weeks of free time and adding me to over 40 suppression lists. And Incogni will continue to conduct ongoing removals because even if the broker removes your data once, they can collect it again. And Incogni makes sure that your personal information stays off the market for good. So if online privacy is important to you, give Incogni a try. So if you click on the link that's on screen or down below, you can try Incogni risk-free for 30 days or get a full refund if you're not into it. And if you do decide to keep it, you'll still get the exclusive 60% off discount so long as you use my link or the code LegalEagle, all one word, at checkout. So after you sign up for Incogni, click over here for more Legal Eagle, or I'll see you in court. This channel has had multiple imposters stealing all of our videos, and YouTube did nothing. You know, it happens. People like to do dumb things with our videos, but things started to worry me when one of the imposters started getting hundreds of thousands of views. And that's when I knew that I had to act and do something about this. Now, over the last 7 years, this channel has generated literally millions of dollars for YouTube, which doesn't necessarily entitle us to any special treatment, but you'd think that YouTube would want to at least keep us in business. And, you know, if a lawyer reaches out to you and says their videos are literally being stolen, you'd think that YouTube would listen. But it took weeks and actually a lot of hard work on our end to convince YouTube to do anything about it. Now, a lot of you already know what we're talking about because as hundreds or maybe even thousands of you pointed out, it looked like there was one person who started several imposter channels of LegalEagle, including The Legal Lens, Think Like a Lawyer, Verdict Vision, and Courtroom Clarity. And each one of these channels was completely ripping off entire videos, re-uploading them with the thumbnail, with some weird stock footage and a vignette over our faces. And of course the channel pages were using photos of me, my entire name, Devin James Stone, trademarks, copyrights, our likenesses, you name it. This channel was ripping absolutely everything off. And I guess because they were using this weird stock photography vignette thing, this wasn't showing up in our copyright management system. So I had no way of taking these videos down myself. They seem to have all been started by someone named Nicholas. The name Nicholas appears in a lot of the different channel URLs. This guy really liked using my entire identity and intellectual property. But thank you so much to everyone who reached out via the comments, email, Blue Sky, and Reddit. It was actually heartening that so many of you reached out and let us know about this problem and apparently notified YouTube about this imposter. I got so many comments and emails that I had to stop responding, but I really appreciate it. But what I don't appreciate is how YouTube basically ignored all of your reports and failed to do anything about this for weeks and made us jump through a ton of hoops to get this thing taken down. But since I'm a lawyer, I documented everything, so let's review the evidence. So in August, I reached out to my partner manager and YouTube directly, and I said, hey, a spate of channels have cropped up that are stealing my content name and trademark. Here are some of them, and listed the URLs. To which I got a response. You have two options. You can use the copyright match tool in YouTube Studio, or you can send an email with all of the infringing URLs. In the email, you should create clear numbered bulleted list of the URLs and include a whole bunch of other information. And they say specifically, since it's a legal process, is it though? Not really. It has to be explicit. You can't just say all videos on this channel. Now, that was a bit of a problem because by this point, all of these channels had uploaded hundreds of our videos. So to chronicle all of these different videos would take a pretty long time, especially as they would request later to collate those videos against the actual infringing videos that we had originally uploaded. And I really wanted to say all of the videos on this channel because all the videos on this channel were stealing our videos and were using our thumbnails and titles as well. So I responded and explained this. I have the copyright match tool, but because the video filter he used, none of the videos are showing up as matches. I can send you a list of the videos, but all of his videos are offending, and on top of that, he's using my image, name, and trademarks in his channel banners and other branding, so it's not just videos. YouTube responded asking for more information. They wanted a clear description of the copyrighted work, again, our original videos, the URL of the infringing videos, a statement that you have a good faith belief, a statement that it's accurate, you're the copyright owner, etc., and your full legal signature. So I said, sure, I'm writing to demand the removal of several channels on YouTube that are copying my videos wholesale and reposting them on their own channels. Their channels are stealing my copyrighted information, trademarks, and likeness without my permission. Every video that has been uploaded has been nothing but a repost of my own wholly owned content. You can contact me as a lawyer at my law firm, and the copyrighted information includes photos of me, my trademark logos, my word marks, my name, as well as copying in their entirety several videos of my channel, including this one, and this one. The entire channels are infringing on every video contained therein. The channel URLs are this one, and this one. I have a good faith belief. The above information is accurate and I own the copyright and trademarks, etc. Signed, Devin James Stone, Esquire, which ironically is the name that appears on the channel pages of all of the infringing channels. To which YouTube responded, looping in copyright. See the request below. Now this was a red flag because I know that YouTube has several creator-facing departments. Copyright is one of them, trademark is another, and generally speaking, YouTube tends to take trademark infringement a lot more seriously than they take copyright infringement. So that's why I wasn't sure to include the fact that they're infringing on my trademarks. And of course, there are teams dealing with identity theft, which is why I said, hey, these channels are imposters. But apparently the copyright team responded, we require a more detailed description of your copyrighted work. We won't be able to process your request until you've provided us with this information. We encourage you to provide whatever specifics you feel will be most useful. Information such as the title of the work, the type of work, the author's name, the date of the creation of the work, the copyright registration number if the work is registered, and or the specific timestamps at which your work appears in the video in question will greatly assist in the processing of your request. Now, this is the point where I got a little bit ticked off. Because if anyone had taken the time to just look at the imposter channels themselves, they would have seen that it was stealing the videos in their entirety. They were stealing my name, stealing my likeness. They were using literal headshots of me in their channel pages. And when you're asking for this kind of detailed information, it sort of makes sense when there is one single video that is pirated from all of your other videos. But the thing is, again, this guy was pirating hundreds of our videos, and it would take probably a full day's work to go through, chronicle all of them, and say, here's the offending video and here's the original video. Look, they're identical, completely identical, including the title, thumbnail, the audio track itself, and everything that appears in the video except for the stock footage that was very ham-fistedly shoved into the video. So that's how I responded. Hi, all the channels that I mentioned consist of nothing except re-uploaded content from my channel. Every video on their various channels is a re-upload from mine. It is not a question of one video pirating a single video on my channel. Everything on their channels, including my likeness and name, is stolen from my channel. It should not be incumbent on me to match up all the dozens of videos on their channel to the videos that were stolen from my own channel. In any event, the titles and thumbnails are identical. To which they responded, we understand how frustrating this can be. Do you? Do you really understand how frustrating this can be? It's not just the pirating of the videos, it's YouTube's response that's a little bit frustrating here. In order for this copyright takedown process to work effectively, but see, this is the problem. This is not the copyright takedown process. This is an imposter who is violating my copyright, trademarks, and intellectual property. All of it, including my entire identity, has been stolen here. You will need all of the necessary information upon submission. If you are able to provide your original video URL paired with the infringing URL within the same submissions, that should allow the copyright experts to act much quicker. To which I responded, again, a little pissed off at this point. In the time that it's taken to respond, or more accurately, not respond to my notice, the person in question has now uploaded hundreds of my videos and garnered hundreds of thousands of views. I have received hundreds of emails from individuals concerned about this act of piracy. Those same people have stated that they have reported the channel in question, yet so far YouTube has done nothing. Ironically, the stolen video that received the greatest number of views on the pirate channel is demonetized on my own channel. That was true, by the way. It was a video about Epstein that's completely demonetized, not generating any revenue whatsoever on LegalEagle. But, you know, I guess the pirate can maybe earn the money that I never could. But as requested and required, at our own expense, we have compiled a list of the offending channels, the pirated videos that appear on that channel, and corresponding original videos that we created. This effort took several days. Please see this link in the attached spreadsheet. As I stated before, this should not have been necessary given that the channel is stealing my identity, including my name and likeness, at a channel level, and every video that they have uploaded is stolen from us. So finally, after we spent hours and hours compiling all of this information, literally within 24 hours the next day, my partner manager responded and said, "Hi Devin, great news. The team has reviewed the channels and determined that it is in violation of our community guidelines." Oh, really? You think? Content intended to impersonate a person or channel is not allowed on YouTube. Yeah, I'm aware. I'm a freaking lawyer. YouTube also enforces trademark holder rights. Do you? When a channel or content in the channel causes confusion about the source of goods and services advertised, it may not be allowed. Yeah, that's called the definition of trademark infringement. For further information, please visit blah, blah, blah. Thank you again for your patience. Well, my patience had run out at that point. So I responded with how I was actually feeling. I was telling you guys from the start that this person was stealing my identity, including my name, trademark, likeness, and identical content. Why did the copyright team keep asking me for more detail? Did no one actually look at the pages that were impersonating me until now? He asked, knowing that that was in fact the case. And honestly, that's what really pisses me off about this whole thing. I kept telling YouTube that there was someone who was impersonating me. I kept telling them that copyright was not the right avenue for this. And only after they made us jump through a huge number of hoops did they actually do anything about it. And then they did it immediately. And YouTube responded, "Our copyright team has to be thorough to make sure we're taking down the right content and following all legal guidelines." Except again, this isn't the copyright team. This was the impersonation team or the trademark team. This means they need to gather very specific evidence to confirm that the content is a direct copy and verify ownership. All these videos are on YouTube. They have copyright matching tools. All they had to do was match the audio tracks from the 2 different videos and they would know. Part of the problem here is that none of these videos were showing up in my own copyright match tool. Otherwise, I would have taken them down myself. So at the end of the day, these channels are finally down. I did not have to actually file a lawsuit against YouTube or the offending idiots who started these channels. So I guess someone finally looked at the offending channels for more than half a second and realized that I was telling the truth, that these people were stealing my entire identity and our copyrighted material and trademarks and all of our other IP. Though, ironically, after this happened, we found another one. Another one of these impersonator channels is still up, the Law Unlocked, though the name in the YouTube URL is Noah Parsons, not some variation of Nicholas. Feel free to go report that channel as well. I will, I guess, reach out to YouTube and they'll probably take care of it, I don't know, in 2026 or something. But look, don't get me wrong, I'm profoundly grateful for the platform and have every intention to keep making content here on YouTube. And it's not lost on me that a creator on YouTube complaining about ripoff channels might sound like some movie star complaining about BitTorrent piracy. Though I assure you, YouTubers make far, far less income than the people working in Hollywood. But it goes to show you that even when you're a lawyer, YouTube still just won't take your word for things. But what matters most here is that these problems directly affect the quality and content that we make. And it stole revenue from us that we would have used to make more videos. But it's exactly because of issues like this that hundreds of us banded together to start Nebula, the sponsor of this video. Because Nebula is a streaming service where you can watch all the content from your favorite creators like Neo, Jetlag, Johnny Harris, Real Engineering, Real Life Lore, and of course, LegalEagle, ad-free and early and legitimately as well. Plus, you can watch countless Nebula exclusive videos made with love, time, effort, and increased budgets that would be too risky on YouTube. Because whether it's some pirate stealing all of your videos or YouTube demonetizing a ton of videos that you have produced this year, Nebula is just an all-around better place to put exclusive content. And at Nebula, we're in it for the longest possible term. And that's why every video we've made this year is on Nebula and is also an extended cut, like the beatdown that Dr. Mike and I gave to the Good Doctor. The Nebula version contains 20 minutes of additional analysis. That's really funny and thought-provoking, but we had to cut it out of the YouTube version. Or you can check out our Nebula exclusive video on how RFK Jr. can legally or not ban vaccines, or a video about unhinged judges that went too far, just to name a few. And if you love deep dives, then I highly recommend you check out Mad Kings. It's a brand new original series from our friends over at Real Life Lore that explores the fascinating secret lives of dictators like Uday Hussein, the Mad Prince of Iraq. And people often ask if it helps the channel more to watch it on YouTube or Nebula, and the answer is emphatically Nebula. The watch time payouts are bigger, and since my creator friends and I created Nebula ourselves, we don't have to worry about capricious demonetization standards, which has been a huge problem this year. Just to name a few, our videos on Roblox, Epstein's lawyers, Ghislaine Maxwell, the Epstein files, Diddy, illegal deportations, I'm honestly losing count at this point. And most of the time we're demonetized for showing the same footage that legacy media companies like CNN and Fox News show on their YouTube channels without demonetization. So if you'd like to support this channel and its mission to demystify the legal miasma that we live in, a great way to do so is by signing up for a lifetime subscription to Nebula. It's truly the best deal of all. For only $300, you get access to Nebula forever, but you better hurry because the price is just about to jump to $500. Either way, you can click or scan now to get set up and continue watching LegalEagle on Nebula, or I'll see you in court.